The following program on KROC is sponsored and paid for by Meshbesher Spence.
Zach Bauer is in the house from Meshbesher Spence. Zach, how you doing?
Good morning. I'm doing well.
Well, wonderful to see you. We're going to talk about a Minnesota Supreme Court ruling here.
Yeah, recent decision by the Minnesota Supreme Court in State versus William Bernard came out on February 11th, so just over a couple weeks ago, and gives some clarification, although not clarification I think that the defense bar was looking for, on the constitutionality of the test refusal statute, which is...
The what?
Test refusal statute is when a person gets arrested for a DUI, they decide, I don't really want to give that test.
Okay.
So the stage is kind of set for this because the Minnesota Supreme Court the United States Supreme Court back in 2013 said if you want to get somebody's blood and they don't consent to the test, you need to get a warrant. And in Minnesota, we've had a test refusal statute that's been in place for a long time that says if a person doesn't consent to that test, then we just charge you with refusal. We don't go and get a warrant.
Okay.
And so that was challenged based upon the fact that, well, if you have to really go get a warrant, and that's what the United States Supreme Court is saying, then why should I have to consent to something that you need to get a warrant for? With the idea that if somebody came to your house and was looking for evidence and you said, no, why don't you go back and get a warrant? They can't charge you with a crime for not letting them in to your home.
Mm-hmm.
And so this went up to the Court of Appeals initially, and the Court of Appeals decision was along the lines of, well, if an officer arrests you and kind of has probable cause and they can envision that a judge might issue a warrant, well, then we're going to call it okay. That was kind of generally disregarded as being a very competent decision by everybody, whether you were a prosecutor or a defense attorney. The state allowed it to go to the Minnesota Supreme Court without any objection, said that you need to relook at this decision. And the Minnesota Supreme Court did, and they decided that it's an exception that we call search incident to arrest, that when a person is arrested for an offense, law enforcement can search that person in an effort to either protect officer safety or to preserve evidence. And that's what they did in this case.
And so preserving evidence in this case is staying drunk.
Yeah.
Getting them while they're loaded.
The issue to some degree is that normally that preservation of evidence logic is along the lines of, can the person destroy things? For instance, I have evidence in my pocket that I want to destroy.
Right, you don't get to go to the bathroom.
You don't necessarily, there's nothing a defendant can really do to destroy the alcohol that's in the system other than the fact that it just naturally burns off
it's
over
just
a period of time.
That you're fighting then.
And the Minnesota Supreme Court was extremely divided on this case. The ultimate decision was 4-2 in favor of upholding the constitutionality of the statute. One of the justices abstained, and we don't get a lot of trash talk in the legal world, but there was a ton in this decision from both sides. The dissent, which is when the people that don't win, essentially, the two justices that decided that they didn't think this was decided correctly, get an opportunity to write their own opinion as to how they would have decided. And the quote that's kind of striking at their decision is that in the end, the court ultimately arrives at a decision that is notable for its disregard of the Supreme Court precedent and is also defective for its logic. So it was a scathing kind of opinion
and who wrote
on both
that?
sides. This was done by Justice Page.
Okay.
So it will be something that I think will probably get reviewed by the United States Supreme Court.
Certainly,
I would think.
It goes against what they ruled.
Yeah, it's not. The Minnesota Supreme Court kind of carved out its own niche, saying that, well, we're not really going against them because they only decided this aspect of it. But there's some issues with the logic, certainly. But for us moving forward in the legal world, and for people that may end up in this position as far as being arrested for a DUI, at this point, the law is very clear that you need to consent to a breath test. Mm-hmm. They did leave open the door, saying that they may view blood and urine differently than breath. Some of us are skeptical that that's maybe just plain lip service to that at this point. But at this point, breath test, if you are told that you need to give one by an officer, you need to consent to it. At least that's the way the law is right now.
And if you refuse, you're going to be arrested.
And if you refuse, you're going to be charged with a crime that is equal to or greater than actually taking the test.
How many other states have ruled similarly, or have any?
So,
has any?
Minnesota is a little bit different in the fact that test refusal in Minnesota is an actual crime. In a lot of states, test refusal just simply amplifies your license revocation sanctions. And I think that's where the difference is between Minnesota and some other states, is that we can say, your license revocation is going to be longer now because you didn't you refused the test. Mm-hmm. But charging them with a crime, there's maybe a handful of states, I think 8 of them right now in the United States, that have test refusal as an actual crime.
Now, isn't it, if you get pulled over, obviously you've probably done something suspicious that would arouse, the reason to be pulled over.
Right.
That you've done something. Smelling alcohol, wouldn't that be enough? Do you have to have definitive
proof?
You
could say that it fell on you. Somebody else's drink spilled on you.
So an odor of alcohol from a law enforcement standpoint is going to be enough for them to probably initially get you out of the vehicle and have you perform some field sobriety tests. As we've discussed multiple times, it's probably my advice not to perform field sobriety tests. If they want to have you take a test at the scene to see if you're over 0.08, you can do that, and quite frankly, you should do that because, number one, it can't be used against you later on in court, and secondly, if you refuse to take that test at the scene, that's reason for them to arrest you and take you down to the law enforcement center. But once you get down to the law enforcement center, at least at this point right now, the Minnesota Supreme Court has said you need to take that test. You have no right to refuse.
All right. Well, bottom line is, I guess, don't drink and drive.
That's always the bottom line.
And number 2, if you do get yourself into a situation, need to call Meshbesher and Spence. How do they do that? What's the number?
They can contact us at 507-280-8090 or visit us online at www.meshbesher.com.
All right. Zach, have a great week.
You guys too.
Have a great week.
You guys too.